How are you tonight? Okay. Well, I'm Fulton Sheen, and I just wanted to share a few thoughts to kind of start the meeting off here. And basically, when you take a look at what's happening here, we have two different right-to-life bills, and they're both supporting life. Is one bad and one good? No. They're both right-to-life bills. They both will save lives. And that's the goal, is to save as many lives as we can. And so as we go forward here, it's we want to be able to just understand that this is a citizens' initiative, and the idea is once you get a certain number of signatures, then what happens is this goes to the legislature. And by a simple majority, they can pass these bills, and it doesn't require the governor's signature. And whether the governor would veto it or approve it, it doesn't matter because it's a citizens' initiative, and all they need is a simple majority. So as you take a look at this bill, this is one of the most simple bills that I've ever heard of. I've seen a lot of ballot initiatives, a lot of citizen initiatives, but this is very simple. If the baby has a heartbeat, you cannot abort it. And in a nutshell, that's the way that it works. And so what I think and what the Committee for the Heart Bill Coalition thinks is that, can you sign both signatures? Yeah. Two right-to-life bills. You can sign both of them. Can they both pass? They can both pass, and they're both worthy of passage. So it's unfortunate that there's been some controversy in that they're saying that this one bill could negate the other. But that question has been brought up in 23 other states, of which this heartbeat bill, or a version of the heartbeat bill, has either passed or is in the process of being passed. So this is not new, and they've encountered this before. Because what we want to see is if the Supreme Court was to overrule Roe versus Wade, we want to have the strongest pro-life bill or pro-life law in the state as possible. And so everybody wants to see that that's the case. So right now, there's two things that could happen. They could outright override the Roe versus Wade, or they could throw it back to the states. And when you watch what's going on, that's a very probable outcome. Why are you seeing the most extreme pro-death bills out there today? Why do you see some of the most extreme right to life? Not that you can't get any more extreme, but you're seeing the strongest right to life bills and the strongest pro-choice bills being passed. The reason that's happening is the expectation of the governors in various different states, and the expectation of those states is that's exactly what's going to happen. It's going to get thrown back to the states and be a states' rights issue so that they can decide whether or not in each state whether they're going to allow it or not allow it. And would we like an outright change? That would be best. But throwing it back to the states, that means some states, they'll be pro-life. They'll be pro-life states, while others will be pro-choice states. That's a step in the right direction. And so regardless of what they choose to do, the goal is to have the best pro-life legislation as you can. Now, I'm just going to read you one section of this bill. It's in Section 8 at the very bottom of the of each one of these ballot initiatives. And basically it says right here that nothing in this act, and it says this right here in Section 3, Section 8, number 3, nothing in this act shall be construed as authorizing any abortion that is illegal under any other provision of state law. And then it says, in 4, nothing in this act shall be construed to repeal or amend or explicitly or in implication of any provision of law prohibit or the regulation of abortion, not the violation of this act, in addition in charged with convicted or of sentence in violation of this act. If any court issues an order or judgment that restores or expands or clarifies the authority of the state, of this state to prohibit or regulate an abortion, or an amendment to the United States Constitution is adopted that restores and expands and clarifies the authority of the state to prohibit the regulation of abortion, the Attorney General may apply the appropriate state, apply to the appropriate state or federal court or one or more of the following. And so, bottom line, what it's saying here is this does not affect any previous laws. The strongest abortion law that exists in this state is going to stay in place. It won't be repealed, it won't be overridden, it will stay the same. So you know that Benjamin Franklin said a house divided is going to fall. It can't stand. So what we want to see is not a division on this. We want to see unity on this. Because if we're all working together for that goal, that's how these things can get passed. That's how they can come about. But without that going on, if you create a bunch of division, then we spend a lot of time and energy fighting with something that doesn't need to be fought. So our goal is to see a strong right-to-life legislation go forward in the state of Michigan. And we've had a lot of really great, strong, pro-life legislation in this state. And so these bills, are they a step in the right direction? They're an absolute step in the right direction. So basically what we want to see happen is feel free to sign either one of these bills. Feel free to take either one of these bills around if you so choose. That's great, because both of them begin to move down the court towards the goal we want to see, which is saving children. So I'm going to turn it over to Steve.
Thank you, Fulton. For those of you who don't know Fulton Sheen, he is a great former state representative and one of the greatest legislators the state of Michigan's ever seen. So from him to Gary Glenn to Tom Hooker, they've carried the torch for the pro-life community throughout the last 10, 12 years. What was it, 12 years ago when you, it's been a little while, I can't remember exactly.
I exited in December of 2008.
Okay.
And I was the pro-life legislator.
Right. And then Tom Hooker was as well. Gary Glenn was another passionate one. All three of them are endorsing this Heartbeat petition drive, as well as my boss, who I would say is the one carrying the torch today, that's State Representative Steve Johnson. And so for those of you who don't know, my name is Steve Cara. I work for State Representative Steve Johnson. I'm a legislative aide. One of my jobs in working for him was to craft the Heartbeat bill for Michigan. And in that process, I talked to lawyers from around the state and around the nation. It was an honor and a humbling experience to get to learn so much about state law, so much about abortion, so much about the opportunity that Michigan and the nation has, and what our best route is forward to protect the sanctity of life to the best of our ability. So I want to go ahead and get started just talking about the two petition drives. And then I'll go into clearing up the confusion. Of course, that's what this event's called tonight. I will clear up the confusion in terms of some of the things that have been said, some of the misinformation that's going around. And once I'm done, we'll have plenty of time for Q&A. So please be thinking about your questions throughout this process. I'll answer as many of those as I can. And we should have 45, 50 minutes to do that. Okay, so the Heartbeat Initiative. Once a heartbeat is detected, the baby would be protected. That's the simple. It would be ideal if we could keep it that simple, but just wait. It's not going to be that simple tonight. And I'll make it as easy and straightforward as I can. And hopefully my legal counsel has prepared me to do that to the best of my ability. So we'll just have to see, and I'll do my best. Dismemberment ban. It's a procedure that's done in the second trimester. That's 13 to 24 weeks. It's a torturous process. What happens is the abortionist goes in and they rip apart the baby, limb from limb, crush the skull. It's gruesome, it's torturous, it's terrible. It's just even thinking about it is unfathomable to think that that's something that would be legal in society. Okay, so we have our first question. If I've already told you this, don't answer. If I haven't, what is quickening? Does anybody know? Have I not told you?
No, I just know.
All right, you're eligible. What's quickening?
I've had 3 kids. So quickening is when you as the mom start to feel movements.
Very good. When the mother can feel movement in her womb, that's called quickening. That typically happens on average between 16 and 18 weeks is the typical time that the mother can first feel movement. In common law, this was something that was talked about. They always talk about quickening, whether it was in English common law, whether it was in canon law. There's a lot of history that talks about quickening. Thomas Aquinas, and they didn't really have a better way to be certain that a baby was existing in the womb until the point of quickening. All right, so hopefully we can read these, but I'll go ahead and read them to you. So these are the 1846 abortion laws. There are others. These are the main 2 that we need to look at to understand the current state of affairs. In this first one, section 33, it says, every person who shall administer to any woman pregnant with a quick child any medication, drug, or substance whatever, or shall use or employ any instrument or other means with intent thereby to destroy such child. Those are 3 important words right there. Destroy such child. It shows the child as a victim at the point of quickening. Unless the same shall have been necessary to preserve the life of such mother. Again, we've got another potential victim in the mother there. Or shall have been advised by 2 physicians to be necessary for such purpose, shall in case the death of such child or of such mother be thereby produced, be deemed guilty of manslaughter. That's at the point of quickening. And then the outright abortion ban from 1846, the one right below here, section 34, says, every person who shall willfully administer to any pregnant woman any medicine, drug, substance, or thing whatever, or shall employ any instrument or other means whatever, with intent thereby to procure the miscarriage of any such woman. It's the woman's miscarriage. It belongs to her. Or shall have been advised by 2 physicians, unless the same shall have been necessary to preserve the life of such woman, or shall have been advised by 2 physicians to be necessary for that purpose, shall upon conviction be punished by imprisonment in a county jail not more than 1 year, or by a fine not exceeding $500, or by both such fine and imprisonment. So that's looking more towards a misdemeanor if it was pre-quickening, not as harsh as it would be once the child was quickened in 1846. So then, in 1931, we got Public Act 328. It was a revision to the Penal Code. And so what that did was they reworded some of that structure from 1846. Actually, it was pretty good. They upped the penalties. So no longer was it a misdemeanor up to 1 year. We're now looking at a felony. It says, with intent to procure miscarriage, any person who shall willfully administer to any pregnant woman any medicine, drug, substance, or thing whatever, or shall employ any instrument or other means whatever, with intent thereby to procure the miscarriage of any such woman, the miscarriage of the woman, unless the same shall have been necessary to preserve the life of such woman. Again, it's the life of the woman. They're not talking about the unborn child here. Shall be guilty of a felony, and in case the death of such pregnant woman, again the woman, be thereby produced, the offense shall be deemed manslaughter. The victim in this is the woman. I don't see anything in here about the unborn child being a victim. So here are the alleged concerns with the Heartbeat bill. 1, it could compromise the existing abortion ban, which we just read, MCL 750.14. This is the least well-founded of the 2, which we will go over eventually. The better-founded one is the fact that it will be found unconstitutional until Roe v. Wade is, quote, overturned. So that is a better argument. The Heartbeat bill cannot take effect in Michigan, while Roe v. Wade, as it stands currently, says that you cannot ban abortions pre-viability. And their idea of viability right now is, at the moment of viability outside the womb, not viability to come to full term or some kind of other mechanism of viability. So as it stands currently, the heartbeat bill will be found unconstitutional. It's called enjoined. It's going to be an injunction by the court saying, hey, this can't take effect because of the supremacy clause, Roe versus Wade, the U.S. Supreme Court spoken. This can't go in effect currently. So that argument is reasonable. It is a reasonable argument. But they say overturned. And technically, that's not fully true. It can be de facto overruled. We'll go over that more later. And it can also be that the Sixth Circuit can uphold it as constitutional. If the U.S. Supreme Court doesn't say otherwise, and the Sixth Circuit Court of Appeals, which Michigan's in, says, hey, heartbeat bill's constitutional, they say that out of Ohio or Kentucky or Tennessee even, we can apply our heartbeat bill here in Michigan. So it's possible without Roe versus Wade being overturned. So we'll get into more of that misinformation later. Okay, here is some Kalamazoo right to life misinformation. This went out in the newsletter, and it's important that we see what has been said that is incorrect. I will run through these step by step. These are not handpicked, but there was 6 in a row that were boom, 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 a lot of misinformation. There's other misinformation, but I didn't want to cut it out, so I just stuck with just these 6. And I thought this was sufficient to run through. We didn't have to go through everything. If it's in yellow, it's misleading. If it's in red, it's wrong. The dismemberment ban would prohibit a method of abortion. Okay, that's misleading. It would prohibit it if it doesn't get enjoined. But given the current state of affairs in Michigan, is it going to prohibit dismemberment abortions in Michigan? The odds are not good. It'll probably be found unconstitutional. We'll go over that more later, but just like the heartbeat bill, this probably won't ever go into effect in Michigan, at least not currently under Roe versus Wade. It has problems with the undue burden standard under Planned Parenthood versus Casey. Would not repeal our existing 1846 law. That's a very bold claim to make if you're saying that the heartbeat bill could or would compromise the existing ban. That is a very bold statement to make and incorrect. A heartbeat bill would replace our 1846 law. No, it wouldn't. It would not do that. They can overlap, they can work in tandem. There is reasonable construction, as we'll go over later, for why both this and the outright abortion ban can work at the same time. Michigan would permit legal abortion through the first 6 weeks of pregnancy if the heartbeat bill is enacted. No. Would? I mean, if you said could there, that's like a 1 in a million chance. And it would take a rogue activist judge, and they could use the dismemberment ban to do the same thing if they wanted to. So that could is ridiculous, but that would is false. A heartbeat bill would weaken our existing law. It's just restating what we've already said there. It's continuing to say, so it's not just one mix-up, but it's again and again and again. That's not true. We already have a bill that is more restrictive than a heartbeat bill. I don't know what bill. Technically, this is misleading. We have a law that's been enacted. I work in the legislature. I don't know all the proposed legislation right now, but I don't know of any bill that's more would protect the unborn more than the heartbeat bill that's currently being considered. A bill is something that's not already in law, but it's proposed. So that's a little bit semantics, but it's not a bill, it's a law. So the current law prohibits abortion from the onset of pregnancy at conception. That's actually false. Our abortion ban, we do not have sufficient reason to know for certain that MCL 750.14 protects all lives from the moment of fertilization. When they say conception, they actually mean fertilization. It's a little bit of a semantics thing, but conception is sometimes construed to be when the unborn baby implants in the mother. Fertilization is when the sperm and the egg unite. So we actually mean that fertilization when we say conception here. But the point that I'm making that's wrong here is that we do not know for sure that that's going to be enforced. That's an archaic law. We'll go over it more later and the problems with it. If Roe is overturned and the matter of abortion policy is returned to the state, our 1846 law takes effect immediately and abortion is banned, period. Not according to my research, not according to the legal counsel I've received. I've heard that the state Supreme Court needs to issue an opinion. It does not take effect immediately. This could take months, it could take years, and we don't know what opinion they're gonna draw. They're gonna look at things like People versus Nixon, and People versus Bricker, and Larkin versus Callahan, and Mahaffey versus Attorney General. They will also look at People versus Segura. They're gonna look at that case law before they make their decision on how the state of Michigan would move forward. And that's assuming that Roe versus Wade is overturned. I want to see Roe versus Wade overturned. It might, but it's not likely. That's not how landmark decisions work. They chip away at it. So eventually we might get back to a place where we could theoretically enforce our outright abortion ban on its face, but on its face is how you and I read it. When you and I read it, it says any abortion is illegal. Anybody in this room, including me, when I read that, maybe not Tom, but anybody else in this room, when they read that, they would say, oh yeah, all abortions are legal in Michigan. Well, it's not always that simple. It depends on how the courts interpret them. Okay, if the Heartbeat Bill is enacted, it replaces our old law. If Roe is overturned, the Heartbeat Bill, oh sorry, that's two different ones. If the Heartbeat Bill is enacted, it replaces our old law. Well, we've already said this one, that's still not true. If Roe is overturned, the Heartbeat Bill takes effect immediately. Well, I appreciate that false endorsement, but the Heartbeat Bill doesn't even take effect immediately. We still need that opinion from the state Supreme Court, but I appreciate them throwing us this bone here. Abortion is banned after 6 weeks of pregnancy. That's misleading. It seems to be implying that it's not banned prior to 6 weeks. Not under the Heartbeat Bill, it's not. It would not be banned prior to 6 weeks currently under the Heartbeat Bill. But that doesn't mean that the outright abortion ban we have, if it's interpreted the way we want it to be, that wouldn't still apply. And nothing about the Heartbeat Bill should tell us anything contrary to the fact that they both should be able to work in tandem. So the answer is clear. Which law is more restrictive? Which law has the potential of saving more abortions? It may not be clear yet. It will become more clear as we go through the slideshow. But the answer to me is clear, that the correct route forward, I'm not saying not to do dismemberment, but that Heartbeat is the correct route forward. All right, so I went to a meeting here in Kalamazoo last month and listened, and there was audio that was sent to me that captures Chris Gast. He's the spokesperson for Right to Life in Michigan. So this isn't just Kalamazoo Right to Life. Hopefully the audio will work. We're going to find out here in a second. And let's see what we have here.
The only way a heartbeat ban could ever go into legal effect in Michigan really is if a pro-abortion judge abuses the intent of it and uses that ban to stop our 100% abortion ban. Because what we have is you can't ban all abortions in the state and also ban abortions only after 6 weeks. So one of those laws is going to have to get thrown out for Roe versus Wade is thrown out.
Sorry. So what you're saying there at the very end is that one of the laws, either the abortion ban or the Heartbeat Bill, are going to have to be thrown out, is the last thing that he said right there. And that was the key false statement. They do not have to throw one of the two out. That's misleading. It's unfortunate that that misinformation, when people are going around and training on the dismemberment ban for their petition drive, instead of simply advocating for the dismemberment ban and pushing the importance of doing the dismemberment ban, when they bring their paperwork comparing Heartbeat to dismemberment to the outright abortion ban, when they bring a 2-page information on why the Heartbeat Bill's wrong for Michigan, when they put it on their slideshow, and when they take several minutes to explain to everybody there, and in their meetings when they go around the state, why the Heartbeat Bill is wrong for Michigan, and they're wrong. I just think you guys deserve the truth. And that's why we're here tonight, to get the truth. We're only about 10% of the way there. The ride's gonna get fun, I promise you. But that's where we're at, and the truth hurts sometimes, and it's not easy, it's not comfortable. I don't want this weight on my shoulders, but I've talked to the lawyers. I know what they've said, and I've heard what's true, and I've heard the misinformation. And I want you all, and not just to those of you in this room, but everyone, if we want to be the strongest pro-life community in Michigan, we need the correct information. we need the correct information. Misinformation is going to lead us to not be successful in carrying out the operations we need to do to protect the unborn. We deserve better than that. I don't want to have to do this tonight, but I feel compelled to. It could have ramifications on my future, but I have to do this. It's more important than my life.
And the best case scenario for your bill is it gets immediately thrown out and doesn't save a single life.
So the best opportunity for the heartbeat bill is that it gets thrown out and does not save a single life. Well, the heartbeat bill was crafted to be the arrow in the heart of Roe versus Wade, and we'll continue to go over this more later. But the more states that pass the heartbeat bill, the more likely we are to get redressed before the Supreme Court to look at Roe versus Wade, to overturn it, overrule it, to do something to reverse it so that the states can restrict abortions more than they currently are. This is a well-crafted bill, and the more states that do it, the better our odds. And that's why Michigan needs to join that nationwide movement. So, best case opportunity of getting tossed out, why? That way Michigan doesn't help with that process? That way we don't make it more right for review? I don't know. I disagree. Oh boy, I'm coming over here. Okay, Right to Life of Michigan website misinformation. Okay, much easier. The heartbeat petition drive is not organized by Right to Life of Michigan. That's true. Nothing was wrong in that. This is what looks like 7, just copied and pasted right off of their website, and just going through piece by piece what we have here. Michigan law already bans abortions before and after a heartbeat is detected. Maybe as you and I read it in statute, but as we'll see, that is not necessarily and certainly true, that that's how the state courts are going to interpret it, so that's wrong. And it can be fully enforced again. This is misleading. When they say can be fully enforced or fully enforceable, those are correct. That's not untrue. But when you and I hear the words fully enforceable, we think, oh, it's going to be fully enforced. Well, fully enforceable and fully enforced are two different things. A heartbeat ban can't go into effect until Roe versus Wade is overturned. Just like we saw earlier, it can be de facto overruled, like Plessy versus Ferguson was by Brown versus Board of Education. And it can be de facto overruled, or the Sixth Circuit Court of Appeals can say that it's constitutional. So there are other routes. Our 100% abortion ban would also then be fully enforceable. Just like that one before, can be fully enforced or fully enforceable. When you read that, you might think that it's 100% or a 99% or 99.9% chance. The number's nowhere near that high. It's nowhere near that high. We'll get into it. Making the heartbeat ban irrelevant. Well, for one, the penalties in the heartbeat ban are higher than they are in the abortion ban, which just says felony. So it's not irrelevant because you're upping the penalties. So there's that and several other things, but that makes it not irrelevant. A heartbeat ban can never go into legal effect or stop a single abortion in Michigan. Well, if our current archaic law from 1846 and then revised in the Penal Code by Public Act 328 of 1931 is not interpreted by the courts to still hold water, if it's seen as archaic, which it has been, and we don't enforce it, then the heartbeat bill can do a lot of very good, a lot of very good. The U.S. Supreme Court can use any pro-life law to overturn Roe versus Wade, including a dismemberment ban. Yeah, they can, but in the decisions of Roe versus Wade, I haven't really read through Doe versus Bolton too much, so I don't want to speak to that too much. I'm a little bit light in my knowledge on that. But in Planned Parenthood versus Casey, when you read through that case law, it's almost like it's telling you the playbook for how to proceed moving forward without telling you. Basically, if you want to reverse Roe versus Wade, you need to do X, Y, and Z. You need to go about it the proper way. So, can they use any? Well, they've made it quite clear that they want the correct angle because they don't want to compromise the legitimacy of their court. They say, oh, we already said something back in 1973. We want an extremely compelling reason to believe that we should, say something different than what we had said before because we don't want to make ourselves look bad. Well, I don't know, I don't care if they look a little bit bad. The problem was in 1973 when they made the mistake. And so to continue to perpetuate that for more and more years, while millions and millions of more unborn people die, just so that they can save their face, I don't think that's worth it. A pro-abortion judge could abuse the heartbeat ban to stop our 100% abortion ban from being fully enforceable when Roe v. Wade is overturned, keeping abortion legal in the first weeks of pregnancy. An activist judge could do that. If I want to go, who likes going to the beach? Some of you like going to the beach. Good. Have you ever decided not to go to the beach because you might get in a car accident and die on the way?
No.
No, you go to the beach. You go to the beach. This 1 in a million chance, you could die on the way to the beach. The odds are so low, they're so ridiculous, and the fact that we even have to have this conversation about could, and even when you say you would, like we did earlier, and it's not just from the Kalamazoo Right to Life newsletter, it is from all around the state. I've seen dozens and dozens and dozens of cases of this misinformation, from this concern about the car accident on the way to the beach, to all of a sudden, oh, this would destroy our abortion ban on the books. That's holding us back. That misinformation is holding us back. And it hurts. It hurts. And I don't want to have to stay up till 2 o'clock in the morning with Alexis helping me. She did all this great work with putting this together. So thank you very much, Alexis. I don't want to have to do that. I don't want to start, well, we do have fun with play some Dr. Mario too. But I don't want to have to do that all the time. I want to do other things with my life other than have to defend this. I want to go out there and say, let's protect babies with beating hearts. And I want to leave it at that. I don't want to have this conversation. But I have to. I have to. That is what tonight is about. Our dismemberment abortion ban would take away the most common late-term abortion procedure if it is not enjoined. So that's, maybe it should have been read. I mean, to say that it would, so I guess technically it didn't say will. Would leaves the door open to what is the definition of would, and I guess technically it's only misleading, so yellow was probably right here. And will save lives. We don't have empirical data to say that. They're just going to find another way. If we ban this abortion procedure, they're going to find another way. Perhaps it's less convenient for the mother, and it might save a few lives. It might. Perhaps those few lives that it saved get counterbalanced by the fact that the pro-choice community is up in arms over the fact that we banned the abortion procedure that was most preferred in the second trimester, and because of that, they just go more reckless. They don't use birth control, and they use abortion on demand as their birth control instead, just to retaliate more. It's a little bit ridiculous, but will it save lives? I don't have empirical data. I think some women will not get second trimester abortions, and I agree with that because we banned dismemberment. But I can't say for sure that this is going to save lives. I cannot say that. There is a legal path for it to be upheld by the U.S. Supreme Court if they aren't ready to overturn Roe v. Wade. Oh, this is in blue. I know, it's a weird color. Didn't tell you about this one. This is technically not true, but it's not their fault because this is written before the decision we got out of Alabama that the Supreme Court said, hey, look, the dismemberment ban, we're going to refuse to take it up. Even Clarence Thomas said he's refusing to take it up. It's not the correct challenge. So even the U.S. Supreme Court saying dismemberment's wrong. So do we still press forward with it? That's our decision we have to make. You know, do we support both? I don't want to deter any of you from it. Just go ahead and support both. I will be blunt. I'll be more blunt later tonight about this, but you deserve that bluntness. Sorry, this isn't as fun as we might have hoped that it would be tonight, but it's what we need. It's what we need. Focusing on a dismemberment ban helps us educate Michigan citizens about the violence of abortion, just like the movie Unplanned. That's wonderful. And that culture change can have benefits. It can help to change hearts and minds. Just going around in public and talking to people about dismemberment and ripping babies apart and saying, hey, do you support ripping babies apart while they're alive? And you ask a pro-choice person that or somebody who's kind of apathetic, that might get them thinking. And they might become pro-life. So it might change those hearts and minds, and I think that it will. I have confidence in that. I want to see Governor Whitmer veto the dismemberment ban. It passed the House and Senate simultaneously, and for procedural reasons, it did not go to the other chamber yet, and so they have not sent it to the governor to veto. It's not my decision. I'm not involved in that decision-making process, but the greatest value I see in that dismemberment is the public perception, and if Governor Whitmer is going to have the audacity to publicly say that she's okay with ripping babies apart while they're alive, and she's going to make that stance, she can look very bad doing that, just like the pro-choice legislators did already. Go ahead and make her take that stand, and make her look really bad. I don't think it's happening. I wish that we would. All right, here's the penalties. 1931 abortion law. It's a felony if the woman does not die, so that's up to 4 years. And it's manslaughter if the woman does die, which is up to 15 years. So in talking through this with the lawyers, I went back and forth with this a little bit. My final conclusion was, well, later abortions, whether I agree with it or not, because I think that life begins at fertilization, and I have high confidence that I know that life begins at fertilization. But if you take the aggregate of society, third trimester abortion procedures are seen as more egregious by the aggregate of society than first trimester abortions. So a blanket abortion ban, having lower penalties, is reasonable construction with the fact that the heartbeat bill has higher penalties. Does that make sense? It's reasonable to say that because third trimester or second or after heartbeat is even worse than, not that you and I see it that way, because if you're like me, you believe life begins at fertilization and it shouldn't matter at what point. That doesn't matter, but when you take the aggregate of society's view, third trimester abortion procedures, there's a lot of pro-choice people out there who are not comfortable with third trimester abortion procedures. So once you take that legislation that would be not going all the way back to fertilization, and you take it from a different point, the penalties, in my understanding, should be higher. That makes for a reasonable construction. Not that it's needed. Repeal by implication. Repeals by implication are not favored and will not be indulged in if there is any other reasonable construction. This is from case law here in the state of Michigan. It's from a Court of Appeal decision. It's called People versus Hagera from 2001. What Hagera did is he was a physician, and he did an abortion on a 28-week unborn child. So they were looking at this, and he was trying to make the argument that he should be innocent because other pro-life laws were passed, including informed consent, partial birth abortion, things like that, where when those were passed, that they meant to repeal the existing law. That by passing that overlapping abortion law, that they meant to repeal the existing law. Like the whole concern we have with the heartbeat bill doing that. That's what we have here in People versus Hagera. This is not the only time repeal by implication has been seen as strongly disfavored. It is very, very standard. And it's the standard. It is the gold standard for repeals by implication in the state of Michigan. Safeguarding and firewalling any concern whatsoever that the heartbeat bill could, or in some cases, some people say would, compromise the abortion ban. It says, repeals by implication are not favored and will not be indulged in if there is any other reasonable construction, like higher penalties. The intent to repeal must very clearly appear, and courts will not hold to a repeal if they can find reasonable ground to hold the contrary. Those penalties are reasonable ground, and Fulton cheated and told you guys my next slide already. Savings clauses, reasonable construction, absolutely. The first one, nothing in this act shall be construed as authorizing any abortion that is illegal under any other provision of state law, including explicitly or implicitly repealing or amending any existing law, including but not limited to MCL 750.14, 750.15, 750.322, and 750.323. If you didn't notice, that 750.14 is our theoretical outright abortion ban on the books from Public Act 328 of 1931 when we revised the Penal Code. And there's another fun one in there too, talking about the penalties, because those other ones are kind of talking towards policy. That third one says, sorry, I don't have this one memorized. This act does not prohibit any person from being charged with, convicted of, or sentenced for any other violation of law arising out of the same transaction as the violation of this act, in addition to being charged with, convicted of, or sentenced for the violation of this act. So, if there's another pro-life law that has higher penalties, you could be charged under that one instead. Okay, this is the key case law that we have to look at. It's called People versus Bricker. What People versus Bricker is about, Bricker was a non-physician who performed an abortion, and this is what they had to say. We are duty-bound under the Michigan Constitution to preserve the laws of the state and to that end to construe them, if we can, so that they conform to federal and state constitutional requirements. That's pretty good. That's saying basically whatever abortion laws we have on the books, we want to keep those. That's what People versus Bricker told us. This is the case, you see 1973, this is the response that the state of Michigan Supreme Court had to the fact that we got Roe versus Wade nationwide. They gave us People versus Bricker and Larkin versus Callahan. Larkin versus Callahan are about the other three, they're not so relevant. This is the big one. This is about the outright abortion ban. So, they want to preserve what they can of the laws of this state. Not as they're read on their face by you and I, but as they interpret them. They didn't say one way or another how they're going to interpret it, but that those laws, whatever they mean and however they're going to interpret it, they still want to keep that ability moving forward to be able to construe it where they can. So the central purpose of the legislation is clear enough to prohibit all abortions except those required to preserve the health of the mother. That's interesting. When I read the outright abortion ban, I thought it was about protecting the unborn child. But they're worried about the health of the mother, is what it says in People versus Bricker. Now, this is something called dicta. This is not part of the central holding. This is not what the case was about. But pronouncements, like dicta in this case, when the state Supreme Court has the chance to go back and review and decide if Roe versus Wade is fully overturned, if we are that fortunate, and I hope we are, how are we going to operate moving forward? Well, to preserve the health of the mother, we're going to see some problems with that when we get into another case law. Whoops, no, and we did that. Okay, when the legislature adopted the statutes prohibiting most abortions, there was little or no reason to question their constitutionality. They're archaic. The medical and other developments which influenced the United States Supreme Court to decide Roe and Doe, as it did, were far ahead. The Court of Appeals, so People versus Bricker, when it was at the Court of Appeals, said, so not the state Supreme Court decision, but they referenced it in their state Supreme Court finding. The Court of Appeals, noting defendant is not a physician, concluded that as to non-physicians, there is sufficient state interest in both the protection of the health and safety of, not the unborn child, of the pregnant woman, and the protection of society as a whole. They saw a state interest in that. From the practice of medicine, whatever that means, from the practice of medicine by persons not licensed as physicians to justify continued application of the abortion statute to those abortions performed by, not anybody, by non-physicians. Again, this is dicta. This is just a pronouncement. This is not the central holding, and the state Supreme Court is not bound to go back to this. They're not bound to this, what I'm telling you here. But we have every reason to be scared that we don't have an abortion ban in Michigan. We have every reason to believe that. The Court of Appeals for People versus Bricker, by the way, that was pre-Roe. So when they were talking about that non-physician and making it abundantly clear that they were so concerned about non-physicians, they went out of their way to talk about non-physicians. They never explicitly said that physicians can do abortions. They didn't say that in the Court of Appeals for People versus Bricker. They didn't say one way or the other, but they made it abundantly clear they were talking about non-physicians over and over and over again. So the door is kind of open to go one way or the other. This is People versus Nixon. It's a Court of Appeals case of Michigan from 1972. Again, this is pretty raw. And what we will end up reading here is problematic for the safety and the preservation of our outright abortion ban. But again, we need to know before we make our decisions moving forward these kinds of things. Now, this did get negative treatment from a case called Mahaffey versus Attorney General, which is from 1997. But Mahaffey versus Attorney General, again, it was dicta. It's not central holding by the courts, and the Court of Appeal, not the state Supreme Court. But Mahaffey versus Attorney General was saying, oh, our outright abortion ban, it exists, and the reason we know that is because of what People versus Bricker said. I don't know how they got that 100% certainty from People versus Bricker, because I sure as heck didn't. So that dicta from Mahaffey, to me, contradicts what I read in Bricker, which has that door open for physicians. Is this all making sense? Hopefully. We'll have plenty of time for questions afterward. Okay. People versus Nixon. Says abortions, and this is me writing these two. So, but we'll get into quotes from it again like we had earlier. People versus Nixon says abortions in the first trimester performed by physicians should be legal in Michigan as they are interpreting the outright abortion ban, MCL 750.14, and that law is too archaic and hasn't stood the test of time. That's me saying that, but we'll go ahead and see what People versus Nixon actually said and whether or not what I just said there is a reasonable interpretation of what People versus Nixon says. Just so you know a little bit about that case, Robert Nixon was properly charged, tried, and convicted of a felony of abortion. He was actually a physician, but he was treated as if he was one of his non-physician brothers. He was not using proper standard medical procedures. He was not using an antiseptic environment that would be standard for somebody in the medical field to do if they are going to perform an abortion. So here is some actual quotes from People versus Nixon. While we have little difficulty in finding a sufficient state interest with regard to induced abortions performed by non-physicians, the question of whether there's a sufficient state interest to justify continued application of the statute with regard to licensed physicians is somewhat more complex. Medical science has made tremendous, and remember they're saying this in 1972, medical science has made tremendous strides in recent years. No longer is an induced abortion when performed by a licensed physician in an antiseptic environment a matter of so great a danger that it justifies a blanket denial of the right to secure such medical services. Not only has modern medical science made a therapeutic abortion reasonably safe, but it would now appear that it is safer for a woman to have a hospital therapeutic abortion during the first trimester than to bear a child. Safer for her to have an abortion in the first trimester than to bear a child. So if you're looking out for the health of the mother, like we saw kind of in People versus Bricker, then if you're looking out for her health and it's safer than actually childbearing, then why would they not be allowed to have an abortion? It's unclear. It's fuzzy. I disagree with Mahaffey versus Attorney General. I wish I didn't. I wish we had that strong abortion ban on the books, but can't say for certainty what the state Supreme Court is going to say. We cannot say for certainty, and there's great reason to believe that our abortion ban is in peril. All right, faced with this evidence, we are forced to conclude that the intended purpose of the outright abortion ban is no longer existent as it applies to licensed physicians in a proper medical setting. There is no longer a sufficient state interest to justify continued prosecution of a licensed physician for the mere act of artificially inducing a miscarriage of an unquickened fetus. We see an unquickened fetus here. Remember in that section 33 from 1846? They saw a vested interest in the child and don't destroy the unborn child at the moment of quickening. Well, here we see quickening coming up again in 1972. It says there is no longer a sufficient state interest to justify continued prosecution of licensed physicians for the mere act of artificially inducing a miscarriage of an unquickened fetus. This could be problematic for how the state Supreme Court is going to interpret our law moving forward. If they follow People versus Nixon, and if they look at that open door in People versus Bricker, we have no guarantee we have an outright abortion ban. And if we're going to sit here and be concerned about on our way to the beach, we might get in a car accident on the way, so we're not going to go to the beach, we're not going to do the heartbeat bill, that's ridiculous. And the fact that we're even having that conversation makes it go from just a typical drive to South Haven to now we're driving through downtown Chicago with a bunch of 16-year-olds who just learned how to drive on the highway, and now we're trying to get to the beach. Because we just legitimized this conversation in the pro-life community, even sitting here and talking about it. Sorry I brought it up, but I'm not the first one. I'm just responding to those false, unmerited, poorly founded, detrimental accusations about the heartbeat bill. The present Michigan abortion statute has become unproductive of the end for which it was originally intended, i.e. the health and safety of not the unborn child, but the woman. My boss actually asked, he was on the committee that the dismemberment ban went to, and he asked a really good question, I liked it. He asked one of the people who testified, he asked if the dismemberment abortion procedure was safe for the unborn child. I loved it. I loved it. The lady wasn't a doctor, so she pawned it off and said, well, I'm not a doctor, I want to leave that question to somebody else. And I texted my boss and I said, when that doctor gets up there next, I'm like, you ask that exact same question to the doctor. You ask him if a dismemberment abortion procedure is safe for the unborn child. I love my boss, and I wouldn't be working in Lansing if it wasn't for somebody I believed in, and he's one of the best legislators this state has ever seen, if not the best. But he messed up on that one. He didn't ask that same question. He had something else and was like, dumb. He should have asked it. Oh well, if that's the worst thing he does, I still have a lot of respect for him. Okay, Box versus Planned Parenthood of Indiana, Kentucky. So, does anybody remember this from a couple months ago out of Indiana? What they found was that for proper burial. So, there were two components. For proper burial, can the state of Indiana mandate that a proper burial be done for an aborted child? That was found unconstitutional by the Seventh Circuit Court. But it went to the United States Supreme Court, and they reversed that decision. We've got 5 conservative justices who can pass pro-life laws, right? We can do it. Guess how many we had on this one? 7. We had 7. We had a couple of the others come on board. Because they said it wasn't an undue burden. I don't know the exact reasons, but sorry, I'm lacking a little bit of knowledge there, so I don't want to overspeak on that. But it was 7-2, and they ruled on that because it was ripe enough for review. The Seventh Circuit was not the only circuit who had spoken on proper burial. And I don't know this part either, but I do know that Kentucky's in the Sixth Circuit, and since it says Box versus Planned Parenthood of Indiana and Kentucky, sorry I didn't do enough research on that, but I'm guessing that the Sixth Circuit, which we're in, also played a pivotal role in bringing that, ripening it for review before the U.S. Supreme Court. So we got that. That was a victory. The other component out of Indiana was anti-discriminatory laws. Can you have an abortion because you don't want the baby based on race, gender, or disability? And you would think this might be something that our friends across the aisle might agree on. And I wouldn't be surprised if this passed better than 7-2. I wouldn't be surprised by 8-1. Ginsburg is really, really difficult. I don't know about Ginsburg, but I think we could probably get 8-1 on this. But we didn't get anything. They refused to rule on discriminatory reasons. Why? It needs to percolate in the lower courts. Only the Seventh Circuit has spoken on discriminatory abortion procedures. So the U.S. Supreme Court said, hey, we're not saying that this is bad, but we're refusing to take it up right now because we want the experts underneath us to speak, not just the Seventh Circuit, but other experts in other circuit court of appeals throughout the nation to also speak. And once we see more of a groundswell, once we see more circuit courts popping up with this case, then we'll be ready to make that decision. But right now, we're just not ready. So they refuse to rule on prosecution or prohibition of abortion based upon discriminatory purposes. Okay, so here's the Sixth Circuit. It's Michigan, Ohio, Kentucky, and Tennessee. We have heartbeat bills in 2 of the 4 states already, in Ohio and Kentucky. And that's great. And so the Sixth Circuit can take up one of those states and review it for whether or not they say, hey, you know, we want to make a decision in the Sixth Circuit. Is this constitutional? Is it unconstitutional? What do we think is right? Is this in, because it got enjoined in those courts and it's working its way through the court process? And they can do that with only having 2 states. They certainly can. But although judges and justices are supposed to interpret the law for what the law says and are not supposed to be influenced by public perception, they sometimes are. That's why we have Roe versus Wade. We'll talk about that just a little bit more later. But if Ohio, Kentucky, Michigan, and Tennessee all have heartbeat bills, and the Sixth Circuit Court of Appeal judges have to write their decision, they might tweak just a couple words, because all 4 states from their circuit, all 4 out of 4 states said we want heartbeat bills. That might change just a couple words, and that might be the difference that overturns or overrules, reverses in some way, shape, or form, Roe versus Wade. How powerful is that? How important is it for us to be a part of that movement? It is extremely important. I can think of no better thing that we could be doing for protecting the unborn than in joining that nationwide movement. If we have a 70% chance without Michigan partaking in this, and we have a 75% chance, and I'm just making those numbers up, obviously I don't know, but if our odds go up because Michigan passes and enacts a heartbeat bill, and we get a 75% chance to get redressed before the United States Supreme Court, why not make those odds better? Why not change that culture? Why not join that nationwide movement? I have no idea, unless there was concern about compromising the abortion ban, but that is absolutely ridiculous and not well-founded. More states enacting and more circuit courts ruling, ideally with contradicting decisions on similar laws, makes a decision by the U.S. Supreme Court more ripe for review, as we were talking about. The 8th Circuit Court of Appeals, they have ruled on a heartbeat bill already. They found it unconstitutional. They said Roe versus Wade says that you can't ban abortions pre-viability, so they said it's unconstitutional, but they said some nice things. They said that this choice is better left to the states, which might find their interest in protecting unborn children better served by a more consistent and certain marker than viability. This is a very good angle to seek redress before the Supreme Court, to challenge viability in this way. Okay, the Alabama abortion ban. While Alabama's abortion law is great, it doesn't provide a practical nor prudent challenge to the Supreme Court. So I say we need to do to Roe versus Wade what Brown versus Board of Education did to Plessy versus Ferguson. Plessy versus Ferguson is one of the worst decisions the United States Supreme Court has ever made. They said separate but equal is constitutional. That was a very bad decision. And when you're looking 54 years later, and the U.S. Supreme Court, they weren't too sure they wanted to touch it. They were like, well, you know, we don't want to delegitimize the integrity of the court and, overturn or overrule a landmark decision like that. It makes us look bad. Well, just like with abortion, what's more important? Their credibility? I don't care about their credibility. I care about the fact that they're doing good work. I care about the fact that they're interpreting law correctly. I care about the fact that they're protecting the unborn. I care about the fact that they're not saying that separate by equal is constitutional and rational. I'm glad we got Brown versus Board of Education, but the year prior we didn't get it. The year prior, the court they were split. They didn't know what they were going to do. They talked about it, and they said, we're too split on this. We're not ready for this. They got a new justice, and we got Brown versus Board of Education. Any guess on what the U.S. Supreme Court number was next year when they got that new justice? Any guess? It was 9-0. It was 9-0. That new person came on and changed the tide. And I can't remember if it was the new person coming in or the fact that it was a new Chief Justice, but something to that effect. They went from not knowing what they were going to do, so they sat on it, to 9-0 the next year. That doesn't mean that we need Amy Barrett, by the way. We already have our hero on the court. We have Clarence Thomas. So to say that we need all 5 to be stalwart, best in the business, top person who we can trust, we don't need all 5 to have that level of passion for protecting the Constitution and for saying Roe versus Wade and the right to privacy under the 14th Amendment, and to say that because it wasn't enumerated in the Constitution doesn't mean that's still not a right that exists in the 9th Amendment, which is a beautiful amendment, by the way. I love the 9th Amendment. I just like when it's interpreted the correct way. That was ridiculous, and that's how we got Roe versus Wade, was through that. Of course, with Griswold versus Connecticut playing a role in 1965 prior. Alabama dismemberment ban. On June 28, 2019, the U.S. Supreme Court refused to take up Alabama's attempt to ban the dismemberment abortion procedure. Justice Clarence Thomas said he agreed with the Supreme Court's decision not to hear the case, but he said the court's test for evaluating abortion restrictions, whether they would be an undue burden on a woman's right to choose, is demonstrably erroneous. They're just looking for another route. They're just looking for another route. Okay, Planned Parenthood versus Casey. The hope in 1992 was that Planned Parenthood versus Casey would dismantle Roe versus Wade, while it affirmed Roe versus Wade, a woman's right to choose, and added an undue burden litmus test to abortion restrictions. It provided a playbook as to how to proceed prudently in an effort to put an arrow in the heart of Roe versus Wade. I'm telling you, my legal counsel is very good. I'm telling you, Walter Weber from the American Center for Law and Justice and all kinds of other lawyers who I've talked to about this, including Tom Powers, have taught me so much. And I'm just passing on to you what I've learned. And it's an honor and a humbling experience to get to do that. And it's weight on my shoulders that I didn't want. But I have to take that weight because this cause is too important. This misinformation is too bad. This cause for the unborn makes me feel compelled that I have to do this. Staying up till 2 a.m. playing some Dr. Mario. I've been winning about 50% of the time lately. It used to be about 10%, but I'm learning.
Oh my gosh.
Okay, so before we get to questions and answers, we need to do to Roe versus Wade what Brown versus Board of Education did to Plessy versus Ferguson. Michigan needs to join the nationwide movement in making dismantling Roe versus Wade ripe for review. I believe that we need to be part of putting the arrow in the heart of Roe versus Wade. And I hope that Michigan sees the need and the importance and the significance of taking that stand and sharpening that arrow, and we need to be successful with this. So we need to make sure we go out and we get those signatures. We need 340,000 valid signatures. We have till just after Christmas to get them. And then it goes to the legislature, and if they want to pass it, which we have a pro-life majority, and for several reasons they're gonna in high confidence pass it to where it doesn't go on the ballot. They adopt that petition drive, whether it's heartbeat or dismemberment. The plan is you get those signatures, you send them to those legislators. We've got a pro-life majority in both chambers. They adopt that initiated petition, and it becomes law without Governor Whitmer having a chance to say no. That's how we circumvent the pro-abortion governor of this state. I'll open it up to questions.
Do you have petitions circling around, or you don't?
I have them outside.
Okay.
They'll be at the table. Yeah. Okay, any questions?
Can you remind me what you said earlier about repealing implications?
Yeah, so repeals by implication, they're from the court case People v. Segura. There's other ones like IBM versus Department of Treasury and other court cases where the state of Michigan has consistently ruled that repeals by implication, if it's even worth trying to find, are strongly disfavored. So go ahead and pull that back up here when we find it. Oh boy. Repeals by implication. Okay, we're getting close. I don't even know if I need to pull this up, but okay, repeals by implication are not favored and will not be indulged in if there is any other reasonable construction. Quick question for everybody. What would be reasonable construction for the heartbeat bill? I said 2. Does anybody know one of them? What would be reasonable construction? Anybody? Who said that? You cheated. You didn't raise your hand. You were right. What'd you say?
The higher penalties.
Higher penalties. That's reasonable construction, right? We said that outright abortion from fertilization had lower penalties. Once you get to heartbeat, it's even more egregious. It's not necessarily what we believe, but it's the aggregate of society. It's a reasonable construction, whether we like it or not. It's a reasonable construction. Yes, and what was another one?
Well, not a question, a suggestion. You might be able to solve 2 problems at once. Just at the beginning of the act, add one more sentence to it. See, the purpose of this act is to protect the life of the unborn child, because Michigan has got it backwards. And that case you just had up there from the 8th Circuit Court about liability indicated that the state, in order to protect its interest, to protect the unborn child, might want to do a certain thing.
So you're suggesting
that's not our interest. We've got it backwards.
So you're saying we need to make an intent that you're looking out for the well-being of the unborn? You're saying that's
Just one sentence ought to do it. You've got the first paragraph in here.
Unfortunately, it's too late to make a change, but we do say that in Article 1, subsection 2, says something to that effect. But it is too late to change the petition drive. But it says the intent of this act is to protect the unborn living human being from being a victim of abortion and for other purposes. That "and for other purposes" just protects the fact that it does other things as well. But it is too late to change anything. But we're good. We already put it in. Yes.
Would a woman be guilty of anything under the heartbeat law?
Okay, the question was a good question. Would the woman be guilty if she goes and has an abortion done? So both the unborn child, as mentioned, and the women, are victims of abortion in the abortion industry. So no, the woman would not be found criminal for having an abortion. So.
You know what would happen to a woman if she did a self-abortion?
If the woman did an abortion on herself, there's actually a court case on this from 1963. It's called Petition of Vickers. It's a Supreme Court decision. And what do we think? Should the woman be found guilty? Because by that point, if she's not held criminally responsible, but she's the abortionist because she's doing it to herself, should she be held criminally responsible at that point?
Yes.
Yes, the heartbeat.
Yeah, or pre-heartbeat, yes. So the answer from the state Supreme Court in 1963 was no. The answer was no. They said that a woman, it's her body, she's performing the abortion on herself, that she would not be held criminally responsible because you can't be a victim of yourself. There was no venture. What's that?
She has to be held criminally responsible. It's her decision to have it done, and it's murder. It's killing.
Well, that's what we think, but that's not what the state Supreme Court said in
What's wrong with them? What are
1963.
they thinking? What are they teaching in our law schools?
It's unfortunate. It's unfortunate. Yes, it's unfortunately not what we want, but it's the reality of what was said. So I just come here to give the blunt reality of the facts, not saying that I want it to be that way. So.
What's the difference between that and dismemberment? You know, like we were saying earlier, you know, if you're dismembering that person, you're killing them. So what was, how was that different than what she was doing to the child even when she was doing it herself?
Yeah, any abortion, we would believe is wrong. And the question of whether to have the woman be responsible or not, I definitely see pros in having the woman being found criminally responsible, but there's cons to it too. If we want an abortionist to not be found, to not be convicted, the woman's going to be more scared to tattle and to tell her story if she's going to be found criminally responsible. But if she is a victim and an abortionist does an abortion and she's having regrets later and say, hey, you know what, I wasn't given good counsel. I didn't realize how awful this would be and how I'd have to live every single day and go to bed at night knowing that I killed an unborn child. So I'm kind of pissed that I did that. And when I went into Planned Parenthood, they didn't tell me how I was going to feel. This is awful. I'm going to go tattle on that person. I'm going to tattle on that abortionist. And I might be convicted because the woman sought it out. So there's some pros of it. But yes.
Are there any other abortions that are worse than dismemberment that you think? Like if we banned, Danny, you went and said about if you ban dismemberment, there's going to be other types.
Okay, so yeah, dismemberment is the second trimester abortion procedure, yes. And so do I think there are other abortion procedures that are more torturous? Well, this is another blunt reality that I'll share with you all. Yes, dismemberment is torturous. They rip apart a living being, and it takes several minutes for them to die. But the question is, if we ban dismemberment abortion procedures, just like in chess, if we ban this, then what happens? You got to think about the next move. What are our alternatives? So I'll answer that question, but it's going to be a long one. A less torturous one would be digoxin or potassium chloride. And digoxin and potassium chloride, what they do is they inject. Digoxin sometimes used when somebody has a heart attack to try to kickstart their heart again. But if you give an overdosage to an unborn child, it's just a matter of about a second kills the baby. So although all abortions are bad, if we're going to do the abortion, as terrible as it is, it would probably be less bad if we got it over instantly from using the digoxin or potassium chloride straight to the heart. The problem with that, it is a second trimester abortion procedure, but they don't normally do them until about 18 or 20 weeks. Why do you think that is? Any thoughts? You have to have a big enough baby. You need to be able to find the heart. You need to be able to stab a needle in. If the baby's too small and you're trying to stab the baby with the needle, but it's too small, then the needle can just push the baby. So at 13, 14, 15 weeks, when the unborn baby's smaller, that's hard to use digoxin or potassium chloride. It's possible that you could insert something in the mother to cup the baby so it's easier to stab with the needle. I've never heard of it done, but if you're trying to be less torturous, you might be able to do it. A doctor can tell me whether or not that's true. I don't know, it's just an idea I came up with. But my concern is, aside from digoxin and potassium chloride, your other second trimester abortion procedure options include medicinal, like the mifepristol and mifepristone. That's often called RU486, used typically in the first 6 weeks of pregnancy, but they can also do the medicinal abortions in the second trimester. But anybody see the movie Unplanned? Yes. When she's laying in the bathroom, that was an abortion pill. It was not good for the woman. And I wish I knew more about that second trimester abortion procedure. I've tried to research it several times. I've tried to have other people research it for me. I don't know the fetal experience from the mifepristol and mifepristone. I just don't know. I wish I knew. But it takes hours and hours. I do know that, but I don't know the experience. But there are others, including saline baths. What saline baths are is they take amniotic fluid out of the mother and they replace it with a salt solution. And the unborn baby is in the womb with the salt for hours, for days. It's extremely torturous. It goes on and on and on. And so if we don't want to torture them for several minutes, I can see reason to not want to torture them for several minutes. Absolutely, because it's torturous. But if we start getting more saline baths and more prostaglandin, which takes hours and sometimes days to kill the unborn child, it's something we should consider. And it's the blunt reality of abortion procedures. But it is important for us to know those things. And the vast majority of abortions that are done in the second trimester are done in the 13th, 14th, and 15th weeks. Even though 16 through 24 adds up to more weeks, 13, 14, and 15 has the vast majority of abortions, is because once you start to get to those higher weeks, the number of abortions start to tail off because they become more and more rare. Next question.
I'm just trying to understand the two bills here. So the heartbeat bill would stop abortions after approximately 6 weeks.
If it's not enjoined, yes.
Okay. The dismemberment bill is after how many weeks?
It's a procedure. So it's done between 13 and 24 weeks. So it's not banning from a specific point. And the heartbeat bill is not even from 6 weeks either. It's from the moment of heartbeat being detected.
Okay.
So, but again, that would be if it's not enjoined.
Okay.
The reasonable expectation is that both will be enjoined and found unconstitutional.
So I guess why wouldn't we want to go with the one that's going to stop it earlier? And what would the motive of Michigan Right to Life be to want to put negative things on the heartbeat bill?
So, sorry, could you
Oh,
repeat
yeah,
that?
no,
We need the visibility.
what I'm wondering is why, if that's the case, why wouldn't we be trying to get the bill passed that's going to stop abortions earlier?
We would want to, and we need to get that redressed before the U.S. Supreme Court. And that's the extreme power of the heartbeat bill, is it's that beautiful challenge to Roe versus Wade. That's what's so beautiful about it. But both of them are likely to be found unconstitutional because under Roe, we can't have them take effect.
So what would the motive be for Michigan Right to Life to be negative against the heartbeat bill?
Because they say that it could compromise the abortion ban, which is an erroneous concern. It's like not going to the beach because you might end up getting in a car accident. It's just absolutely not a consequential, rational, or prudent concern.
You keep talking about right to life, saying might this, might that, and yet you wrote they might change, the odds might go up. So you're using the same terminology.
Correctly.
And the problem that I have with this whole thing is that the bill, the existing law already makes it a felony to perform an abortion at any time. The new law similarly makes it a felony, but the new proposal, however, specifies the prohibition begins after detection of a heartbeat. The current one is right from the beginning.
So,
by the way, fertilization and conception are synonymous terms. The term you were looking for was implantation.
I have heard from Genevieve Martin, and I took her word for
I
it.
don't know who that is.
She is the head lobbyist for Right to Life of Michigan. She's the one who told me that conception and fertilization are not synonymous. And I don't know whether they are or not, but I do know, I do know that in the heartbeat bill, it says the words conception, not fertilization, but they define the definition of conception, and they define it as meaning fertilization. That's what they define conception as for the purpose of the act. So, again, you were reading the outright abortion ban as would make sense to most people, saying that we have an outright abortion ban on the books. But as I was showing in People vs. Bricker and People vs. Nixon, there's no reason to have full certainty, and it's actually in great peril. What you're reading is not necessarily what the state Supreme Court's going to say is the law of the land of the state. I wish that it was.
But it's all a crapshoot.
It's
The whole thing is,
Like
because what
our-
you're saying is might. It might happen.
our abortion ban is in great peril.
It's an opinion.
It's
Our abortion ban is not anywhere near a full certainty to take full effect as you read it on its
As
face.
I quoted you, you said many times, that law is too archaic and hasn't stood the test of time. Can you give us an example?
I'm saying that it has received negative treatment from People versus Nixon, from Petition of Vickers, and People versus Bricker. And that's a concern for whether or not the state Supreme Court, if Roe versus Wade, if we're fortunate enough to have it fully overturned, that we'll be able to go back to that fully as you're reading it. And I wish that we would, but we cannot be anywhere near certain that that's what we're going to get.
I think
Next
we're
question.
spending a lot of
Yeah, go ahead.
energy on something that we have no control over.
My understanding then, the heartbeat proposal bans abortion, period, after a heartbeat is detected. The dismemberment is just banning a procedure of abortion, but not necessarily abortion itself.
Okay.
Am I saying, do I perceive this correctly?
Yeah, that's so far it's something good, yeah.
Okay, all right, that was, I just wanted you to clear up that point, because to me, that if people looking at right to life, they're not necessarily standing up and saying no to abortion. They're just simply standing up and saying, we just don't like this particular procedure. I'm not disagreeing with that because it is barbaric. However, they are not taking the necessary steps forward in banning abortion at this point in time with what I see with these petitions before me.
Okay, so that specific procedure, it can still be used to compromise the abortion ban. They can use whatever they want to, but the odds are so low, the repeal by implication is so disfavored, and there's reasonable construction in both the dismemberment and the heartbeat, that there should not be a concern. There's no reason to have that concern. Yeah, go ahead.
I just had a question with the PowerPoint. Can that be sent to us in we put our email addresses on there?
Yeah, yep, absolutely. Yep.
Do we need a third bill to prevent postpartum abortion, quote unquote, killing after birth?
So infanticide, well, we should already be fine with that because People versus Burgers is currently construed. I mean, People versus Air said at 28 weeks that wasn't allowed then. So we're fine with that.
Fine with what?
Right now, we don't need, we already have People versus Burger protecting us from infanticide. But yeah, we don't want infanticide either. But to try to stop a pro-choice thing from happening, as ridiculous as infanticide is, when we should be focusing our time and energy in reversing Roe versus Wade, I just think we need to put our time and energy in a more efficient and more rational.
But the scary thing is that there are people that think infanticide is okay. You don't talk about keeping the baby alive for a while, then deciding if you're going to kill it.
Oh yeah, it's disgusting.
That's
It's disgusting, and I think that the pro-choice community is hurting themselves by doing that. So it's unfortunate they're saying that, but I think they're emboldening and making more people who are on the fence say, hey, you know what? That's just absolutely ridiculous. No, I'm not pro-choice. I'm actually pro-life. So they've almost gone too far in New York, Virginia, Illinois. I think they're shooting themselves in the foot, and that might be part of the key component that helps us to overturn Roe versus Wade or overrule it. Yeah, go ahead.
I forget the name, but it's like MCC or something Catholic. I don't remember the exact name. But they have also came out and trashed on the heartbeat bill, keep spreading this information as well. Do you know why a church group would be so, like, you know?
Well, I think I think their intentions are good and admirable, but I think that the information that they've received has led them to go astray from where they should. I don't agree. I'm Catholic myself, And so the fact that they don't want to compromise their abortion ban, yeah, well, absolutely, that makes sense. But that's not a concern. It shouldn't be a concern, as we went through earlier. But I think that they've been misled because they've got a close relationship with another pro-life group in the state. And I think they're being fed bad information, misinformation, and I think that this misinformation needs to stop. We deserve better information. And that's what this is about tonight.
Correct me if I'm wrong, it sounds like the major thing for us to go away with is that Right to Life is out there saying, vote against the heartbeat bill.
Yeah, and it's really
You're
just
saying that, right?
Yeah, and so I want.
You're saying, vote for both of them. Yes.
I would much rather we vote for both. I want to give you a long
I'm really
answer to
scared
that.
because what's going to happen is we're so divided.
Yep, and I want to let you know how that happened. It's unfortunate, but I want you all to know. Here's my story. In October of last year, my boss and I were looking at the state of affairs in Michigan and trying to decide how are we going to operate moving forward. It looks like Governor Whitmer's going to win. We were correct. Well, hopefully we hold a pro-life majority in both chambers. If we hold a pro-life majority, we can do a petition drive. Our plan, that my boss and I, he's a legislator, he's elected and represents people. He's not a lobbying group. So, yeah, the internet, if we can. So we decided we wanted to fund abortion clinics was the plan we wanted to go forward with. We had conversations with Right to Life of Michigan and let them know that's what we wanted. And we're hoping to work with them on it. And things look pretty good. They told us, we're looking to do a petition drive. And it wasn't a guarantee. I'm not saying they went back on their word. But they were looking to do a petition drive to do 3 things on the same petition drive. To defund abortion clinics, to ban dismemberment abortions, and to ban telemedicine abortion. And my boss and I, when we heard that was the tentative plan, we were like, heck yes, like absolutely, you have us on board. Like, this is great. And then a couple weeks later, they came back with new information. And they said, great news, the petition drive is happening. But there's just a little change. We don't want to create confusion and have a petition that does 3 things at once because that can be confusing and people don't know what the petition drive exactly does because telemedicine abortion or maybe they can't really speak towards what it is exactly and it's too confusing. So they said, we're just going to do 1 at a time. And so I'm like, okay, well, hopefully we're doing defund abortion clinics. And we went with banning dismemberment abortions. And I have a friend who's pretty well knowledgeable on abortion procedures and helped to teach me some of the stuff about those other abortions. And so I'm saying, why would we ban one procedure when other procedures are still legal? Some are more torturous and some are less. But we banned the middle torture one. I think we should have banned the saline baths first and then worked our way down if we're going to ban 1 at a time. So, and it would have stood a better chance too, because dismemberment is about 95% of second trimester abortion procedures. And to ban that is seen as an undue burden, more so, on the woman making her decision. Whereas saline baths, which are a more minuscule amount because they prefer dismemberment, well, those other procedures are going to start filling in. And that's the danger that we run by banning a torturous abortion procedure, and instead we get an even more torturous procedure. It's the blunt truth I feel you deserve. I feel you all deserve that blunt truth. But going out and supporting dismemberment, by all means, go out there and do it. Do not want to dissuade you from it, but I want you to know the full facts.
I've been sitting here wondering whether to bring this up because this really bothers me. And I was at the Michigan United Methodist Conference a couple of weeks ago.
Okay.
And this statement was made. This was something that was voted on by the members there, lay people and ministers. The Michigan Conference recognizes that the unborn baby in the womb, as fully human from the moment of conception.
Okay.
Guess how that was voted?
Down.
Down. There was a no. This was the United Methodist Church, West Michigan Conference. Or not West Michigan, just Michigan Conference. We just
Yeah.
combined recently.
Yeah, I emailed a few churches about this event, and they told me, please take me off your mailing list. And I don't think it's because they disagreed on the whole pro-life situation that's going on, I think it's because they were pro-choice. And it's unfortunate that Christian
I
churches
mean,
take that stand.
when we could not even call this a human conception, that bothers me.
Yeah. Yeah.
Like I say, I hate to even admit that my church
Yeah.
voted that way.
Yeah, I'm sorry to hear that.
It's not allowing you to change.
Just a comment on that.
This is the
I mean,
proposal.
when you take a look at Matthew 24, what does it say? It says that many will be deceived, and most hearts are going to wax cold. It doesn't say cave, but it could. And that's what's happening today. You know, people are bending. We don't have rule of law like we used to have. We don't have conscience in the court. We have court by social, by, what do you call it? Social media.
Okay, one more question, and it looks like we might be ready to go here. Sorry about that delay on this video. Go ahead.
So does the heartbeat bill have an exception, like for the safety, for the health of the mother, for the life of the mother, or anything like that?
So the way it's written, it is crafted to be the arrow in the heart of Roe versus Wade. It is crafted, it has the exception for two things, the life of the mother, as well as a concern with a major bodily function that would be irreversible. So it doesn't just say health, it defines exactly what they mean by health, and it's a major health issue. But the nice thing in theory is, even though that can overlap and can have a higher penalty, which is reasonable construction, hopefully we still have our outright abortion ban that doesn't have that component in it and simply says the life of the mother. So hopefully we have that, but like I said, we don't have a guarantee that we have that outright abortion ban. But that's what it says. And there's no rape and incest.
There's no rape and incest? That's
No.
what I was wondering.
Yep, no rape and incest. All right, good. Yeah, let's go ahead and listen to this. This is Walter Weber from the American Center for Law and Justice. I had the opportunity to not just talk with him on the phone and to get all kinds of emails from him, but he will be interviewing him.
Okay.
Gotta turn it down.
Oh, wait, hang on. Pause it first. Hang on. Oh, there it is. I'm not the tech person, by the way. Just everybody knows. That doesn't mean that. Doesn't mean that I am. Don't make me out to be bigger than I am.
It might need more, we'll see.
Okay, well, at least I'm maybe. Oh, it's because it's at the end. Hang on. Almost there.
I just want to start by asking a quick question. There's people in Michigan who are concerned that if we do a heartbeat bill, that it could possibly compromise existing law on the books. What do you think? And is there a way that the heartbeat bill has been written in order to make sure that we protect the existing laws Michigan already has?
Right. You sort of want to take whatever steps you can not to undo the things you have. The Michigan heartbeat bill is currently drafted. It's not a problem in that regard in any respect. Two main reasons. One is under Michigan law, something called a repeal by implication is disfavored. What's a repeal by implication? It means when you're not passing a bill that says law X is repealed, you're instead passing a law which is so incompatible with the previous bill that it seems to suggest that you have intended to repeal the previous bill. And because that's a judgment call, the Michigan Supreme Court and lower state courts in Michigan have said repeatedly that repeals by implication are not favored. That is to say, we assume that the laws that are already on the books stay on the books unless you're really, really clear that you want the new law to supersede the old law. That's number one reason why the Michigan heartbeat bill is not a problem for repealing the existing law. Number two is that the bill itself says this bill does not repeal any existing ban on abortion. And it's like three different ways in the single language.
Yes. One of which was a recommendation from you. That's
point, nothing in this act shall be construed as authorizing any abortion as illegal in any other provision of state law. Very clear, very straightforward. And like you said, it's said two other ways explicitly, including not to compromise the MCL 750.14, which is the abortion ban in Michigan. With all that said, I guess lawyers, from my understanding, they tend to not give a 100% certainty for anything. They often will say something to that extent. So, you could take it from telling somebody, boy, I can't be 100% certain, to somebody else saying, oh, this could compromise the abortion ban, to eventually down the road, some people are misconstruing that and saying this would compromise the abortion ban. So it goes from in my life, I might end up dating Kate Upton someday, right? Is it in cards for me? I doubt it. It's not going to happen. But could it happen? Actually, yes. But does that make sense? How it's like something that could happen, but it's like a 1 in a million chance. And would it take a heartbeat bill, or could they do something else if the judge wanted to in order to compromise the abortion ban on the books? Okay, well, part of the problem that all of us in pro-life movement realize is that judges sometimes act in that. And the Roe versus Wade decision itself is essentially made up. There's no reference to abortion in the Constitution. Yet you had the majority of the Supreme Court saying that there was constitutional right to abortion under the 14th Amendment. And even though there's nothing there to give a clue in that regard. So, could an activist judge come up with some excuse for saying that a substantive law repeals the previous law? Yes, and if they're willing to defy the law to that extent, ignore the existing Michigan case law, ignore the language in the statute, then in that case, they're not going to need much of an excuse to do that with existing law, whether it's a ban on partial birth or a new law on dismemberment, abortion, or informed consent, or whatever it is. If that's their mindset, then you can't stop a judge like that. That's why you need a good judgment. But as far as sure as you can be with the existing case law, the way the Michigan Heart Bill is written is to go along with the landscape that exists currently in the state, which again is you don't assume that a new law is like an existing law is really, really clear, and there's no reason to draw that conclusion. Quite the contrary, the law says itself, this is not revealing any existing bans on abortion. Correct, yes. And so I guess if somebody was to come to me and say, Steve, I don't support this bill because I have these concerns, what should I tell them? How do we ensure that people in Michigan that what they're hearing is not something that should be a concern? I mean, obviously, when we're saying a certain thing and other pro-life people with good intentions are saying something different, I guess why do you think that is? Well, I think what else could you do? I mean, the law says you assume the existing law stay in effect. And if the law you're adopting says this isn't meant to change any existing law, there's really nothing else you can do. That's as sure as you can be. Right. That shouldn't be. Right. And so the partial birth abortion ban that we already have in law in Michigan, as well as the disarmament that's being proposed as well, they have strong savings clauses in as well, as we mentioned earlier. So those protections have been used before, and they've been used this time as well. So each step of the way, I think that the pro-life activists have taken those necessary precautions. But like you said, you can never guarantee that a rogue judge might be an activist and might compromise something that would be egregious. But they all should be protected. And Steve, the other thing to remember is, for a lawyer more familiar, the idea that the same act can be illegal in a lot of different ways. For example, suppose you have a law on vehicular homicide, right? People getting killed because of the negligent operation or reckless operation of a vehicle. Well, the fact that you have that law does not mean it's okay to kill people if you don't use a gun. Right? You can do a specific form of a crime while leaving all the other bans against that crime conduct.
So you're saying that there would not be conflict if you have one law that says something and you have another pro-life law that says something further or in a different way? Those are all pro-life laws and they're not conflicting.
There's overlapping prohibitions or things.
Overlapping, that's a good way to look at it, yeah. Okay, so another question would be, if Roe versus Wade is completely overturned, that would be ideal. There's a good chance that they'll chip away at it, like Brown versus Board of Education chipped away at Plessy versus Ferguson, and it continued to get better and better afterwards. So if we are fortunate enough to just outright immediately overturn Roe versus Wade,
what would the process be for Michigan by that point? Would the abortion ban on the books immediately be enforced, or would it be something that, is there other steps that need to be taken before that abortion ban would be the law of the land in Michigan? Okay, that requires a little bit of a complicated answer. I'll try to break it out into pieces. Okay, you have this law in Michigan that bans all abortion. The state Supreme Court has interpreted the law narrowly. When Roe v. Wade came along and said there's a right to abortion, that created an obstacle to the enforceability of existing Michigan law banning abortion. So what the state Supreme Court of Michigan did in the case of People v. Bricker was say, we're going to reinterpret the Michigan statute to be enforceable insofar as Roe v. Wade left, which means that if you're not a doctor, for example, which was the Bricker case, doing an abortion, that can still be illegal. If you're doing an abortion after viability, and you don't have an important health reason to do the abortion, that can still be illegal. So what you have is a statute that says it bans all abortions, but it's being interpreted to apply within the space that's available under Roe v. Wade. Now, if the Supreme Court comes along, U.S. Supreme Court, and overturns Roe v. Wade, or modifies Roe v. Wade, or retracts Roe v. Wade, does something that allows more abortions to be prohibited. And then suppose your local prosecutor starts charging someone for doing the things which had been protected before the modification, but now are not protected. Well, the abortionist is going to say, hey, I was doing something that was legal under Roe. There's been no change in the law. And there's been no word of the state Supreme Court that this is now prohibited, so it's unfair to prosecute. Now, I don't know that argument would win or not, but I'm thinking it would make it more difficult than if you have the law on the books already said, if you do X, Y, Z, you can't. So if you have a law that says you can't do abortions by dismemberment or after heartbeat or by partial birth, that is a specific prohibition which puts the practitioners on notice. The Supreme Court issues a decision saying that those kinds of laws are constitutional. At that point, you put one and one together, and you may have to go to the court to get a declaration, maybe an opinion from the Attorney General, you may have an announcement to the local prosecutor, whatever you have. You're saying, we have the pieces in place. We have the law that says you can't do it. We have a Supreme Court case saying it's okay to prohibit that. You got to stop. That's a much easier case to make than saying, we have a law that bans all abortions, and we're interpreting it, so now give us the room to do this. We're going to use that existing law to prosecute. You may be able to do this, but I'm saying it's less certain if you have a law. So just to reiterate that, there's no guarantee that if Roe versus Wade is completely overturned, that Michigan's going to have a law on the books that is going to be enforced. There's no guarantee that that's exactly. No guarantee, right. Yes, it would be nice if that happens, but that would require the cooperation of the Michigan Supreme Court, and you'd also have to have prosecutors willing to make set that up. It would, although it is fully enforceable, it'd be nice if we could snap our fingers and it automatically would be fully enforced. Right. But we don't have that guarantee. Just a hypothetical question, would you say that there's a greater chance that the heartbeat bill does not compromise existing law, or would you say that there's a greater chance that the abortion ban, the MCL 750.14 that Michigan has, would end up being fully enforced if Roe versus Wade is overturned? Well, I'm fully confident that the heartbeat bill does not compromise in any way the existing abortion ban. As far as the enforceability of the existing law, if Roe versus Wade were explicitly overturned, I would not know where to put that percentage, because it would depend a lot on who's on the Michigan Supreme Court. Right. And hopefully that's a high number, but we just don't have that. I would like to think it's a high number, but I would feel much less confident putting number on it. Yeah, okay. That sounds good. Thank you very much, Walter. Good help.
All right. So that was Walter Weber from the American Center for Law and Justice. As I said, he has over 100 briefs before the United States Supreme Court. So when the United States Supreme Court is making a decision on something, he weighs in and gives him his expert opinion and his knowledge, so that they can better make their decision if they want to read what he has to say. That's how high-powered this guy is. Anything that went into the heartbeat bill for Michigan, from talking with other lawyers, it all ran through Walter for the final say. It wasn't me who had the final say. It wasn't Representative Johnson. It wasn't legal counsel for the House of Representatives. It wasn't other lawyers from around the state. all of which I had talked to. They all gave me their 2 cents, and they were wonderful. I got some great 2 cents from a lot of lawyers. And we ran that through to Walter, and we got what we got. It's a beautiful law. We need to do what we can to get that done here in Michigan. So I'll wrap it up with that, and thank you for coming tonight, everybody.
Thank you.
Access Vision, your voice, your community.